Good morning. Welcome to this most recent in a series of webinars hosted by GW Law School and our Government Procurement Law program. We're very glad that you can join us. We have over 300 people signed up for a webinar this morning. We're delighted that so many could join us to discuss these issues in cybersecurity and adapting legal solutions to new threats and old adversaries. As I said, I'm Chris Yukins. I'm a professor in the Government Procurement Law program here. I'm going to be moderating today's program during the first hour. During the second hour, we're going to take a break, and I'm going to be describing to you in a minute how you can join it. There'll be a Zoom meeting in the second hour for practitioners to discuss some of the compliance challenges that they're facing in dealing with cybersecurity. During this first hour, we're recording, and this session will be, the recording of this session will be available on the program information page at publicprocurementinternational.com and on the GW Law Government Procurement YouTube page. During the second hour, we won't be recording. It'll be a more informal session. And as I said, it'll be a meeting. It won't be a webinar. It'll be a meeting, so you'll have an opportunity to interact directly with our panelists if you'd like to discuss compliance issues that you're facing in cybersecurity. So after brief introductions, we're going to turn it over to presentations. There'll be presentations by each of our panelists, and then we'll have questions and discussions at the end of the session. And in all likelihood, those questions and discussions will carry over into the second hour as well in the meeting, in the separate meeting. And I'll show you in just a minute how to sign up for that meeting. I should stress that all opinions offered are the personal opinions of the participants, and they shouldn't be attributed to their organizations. Again, thank you very much to our panelists for joining us. Paul Rosenzweig will be talking during the first hour. He'll be talking about the SolarWinds breach. Sandeep Katharia will be talking about the Biden administration response to the SolarWinds breach and other cybersecurity challenges. Moshe Schwartz will be talking about the National Defense Authorization Act for fiscal year 2021, which just passed. He'll be talking about the cybersecurity provisions in that important piece of legislation. Sam Singer will be talking about the Section 889, which is also known as the Huawei ban, and the most recent proposed rule on the ICT, the Internet and Communications Technologies supply chain. Alex Canizares will be talking about the Cybersecurity Maturity Model Certification, the CMMC. And I'll be doing more in-depth introductions for our panelists as we move through the program. And again, after the first hour, we're going to have a separate meeting led by Kate Growley from Crowell and Sandeep Katharia to talk about cybersecurity compliance challenges. If you'd like to sign up for that second hour, and again, you have to register for a separate meeting. You can do that either by going to publicprocurementinternational.com and just going to the program information page, which you see here on the right-hand side of the screen, and dropping to the bottom, and you can register right there. Also, Kate will be putting the registration, the Zoom registration address, in the chat as we proceed through the session. Now, the chat will be monitoring during the course of the session. There'll be the public chat, the full public chat. There's a recording of that, and the recording of the chat, the text recording, again, and the video will be available on Public Procurement International shortly after the program. We have to process it and we'll post it. And again, the video itself is going to be available on the GW Law Government Procurement Program, our special YouTube page. So this is a special webinar because it's a joint program with our sister program, the National Security and Cybersecurity Program, headed by Associate Dean Lisa Schenck. And I've asked her to introduce our first guest, Paul Rosenzweig. So with that, Lisa, I'll pass it over to you.
Many thanks, Professor Yukins, and thank you for all your work on this webinar, including the slides, which have me in a giant picture for the National Security Law Program. Before I turn it over to our brainiac, Paul Rosenzweig, I do want to plug the National Security Law Program at GW Law School. As Professor Yukins mentioned, we have a National Security and Cybersecurity Law Program, which includes an LLM in National Security and Cybersecurity for those with a JD, and an MSL, a Master of Studies in Law in National Security and Cyber for practitioners with experience and no law degree. We also have an MSL in Government Procurement and Cybersecurity. We have a robust curriculum to support these degree programs, including courses in artificial intelligence. Of course, we have cybersecurity law and policy, counterintelligence, intelligence, counterterrorism, foreign access to US technology, information privacy, computer crime, and internet law, just to mention a few. Anyone interested in GW Law's national security law program should just reach out to me and we can set up a call and I can discuss the program and the benefits of the program with you personally. Now I have the pleasure of introducing Paul Rosenzweig. He's a well-regarded expert in the field of cybersecurity. He actually created the cybersecurity law and policy course and the artificial intelligence course for GW Law, initially teaching both those classes. Paul was a groundbreaker in cyber law and began teaching the course he created in 2010 as a professor or lecturer in law. So a little bit about Professor Paul. He received his bachelor's in chemistry from Haverford College, his master's in chemical oceanography from the University of California at San Diego Scripps Institution of Oceanography, and his JD from the University of Chicago. After graduating law school, Paul clerked for Judge R. Lanier Anderson III of the U.S. Court of Appeals for the 11th Circuit. Since that time, he served in all three branches of the federal government, including as the first Deputy Assistant Secretary for Policy at the Department of Homeland Security. Professor Rosenzweig is also a scholar and a critical thinker. Not only does he maintain a cybersecurity consulting company called Red Branch Consulting within DC, he is a senior editor of the Journal of National Security Law and Policy and a member of the advisory committee to the ABA Standing Committee on Law and National Security. Professor Rosenzweig is also a resident senior fellow for cybersecurity and emerging threats at the R Street Institute, which is a nonprofit, nonpartisan public policy research organization. His portfolio there includes legal and policy issues related to cybersecurity, homeland security, national security, and tech policy, including the intersection of privacy and security. Paul is the author of Cyber Warfare: How Conflicts in Cyberspace Are Challenging America and Changing the World, and of a 3-video lecture series from the Great Courses, Thinking About Cybersecurity from Cybercrime to Cyber Warfare, The Surveillance State, Big Data, Freedom, and You, and Investigating American Presidents. He is co-author of Winning the Long War: Lessons from the Cold War for Defeating Terrorism and Preserving Freedom. And he's the co-editor of 2 books, Whistleblowers, Leaks in the Media, The First Amendment and National Security, and National Security Law and the News, a guide for journalists, scholars, and policymakers. Take it away, Professor Rosenzweig.
Well, thank you. Yeah, thank you so much, Dean Schenck, for that kind introduction, and thanks to you and to Professor Yukins for inviting me to join you on this panel. It really is a great pleasure. I always enjoy spending time with my George Washington University colleagues. My affiliation with GW Law is probably one of my proudest affiliations. It may not be the largest in terms of my time commitment, but it's certainly one of the ones that has been most significant for me, and I'm really delighted to join you. So my task in the next 6 to 7 minutes is to lay the background for the rest of our discussion by telling you all a little bit about the SolarWinds breach, how it happened, why it happened, who we think did it, what we think was lost, and you know, to start with a little bit about what some of the legal reforms might be that might address the problem. So let's start at the beginning. The SolarWinds breach is really not just a single breach, but probably at least 3 separate different types of supply chain assaults on America's cyber infrastructure. And I say at least 3 because the one thing that you should take away from this, if you take away anything at all, is that the story here is still evolving. We know more today than we did yesterday, and we will know more tomorrow than we do today about how this happened, who it happened to, why it happened, and what we can do about it. So much of what you're going to hear today is certainly being baked in as we speak, but I think I should encourage you all to think of it as tentative responses given what we know so far. So what was it? It was essentially 3 separate supply chain breaches. One of the Microsoft cloud service system, one of the VMware authentication system, and one, the most famous and notorious of them, of the SolarWinds Orion system that managed enterprise security. So when I say it's a supply chain hack, what I mean is that the flaws that were embedded into the software began much earlier in the supply chain than when they were deployed to, say, an enterprise user like the Department of Defense or Palo Alto Networks or one of the other companies that was compromised. The problems here started long before the software ever reached the victims. And to see that, let me give you an example, a very brief example of how that worked with the SolarWinds exploit. Their enterprise management system, Orion, is something that they deploy to their customers. Some 18,000 customers had this particular version of software. And they, like anybody else, they push patches and updates to their customers on a regular basis. Someone, and we're pretty darn sure it was the Russians, got into the supply chain well before the patching system. They got an entry into SolarWinds' method of creating the software itself that they were pushing and inserted a backdoor, a Trojan, into that software update so that anybody who took the update would be vulnerable to exploitation. Now, the good news is that not everybody was actually exploited. The bad news is that everybody who got the patch was potentially vulnerable to that exploitation. So there are some 18,000 and growing possible victims of this who may have to respond by cleaning SolarWinds out of their system and rebooting from the beginning. As to the victims themselves, what happened was with the entry of this backdoor, this Trojan, the perpetrators, and again, we're pretty sure it was the Russian intelligence service, the SVR, and their malicious action group known as Cozy Bear, or APT-29, was able to then open up the entire cornucopia of information systems in each of the victim organizations. They would have access to confidential information, business information, and emails, that sort of thing. To take but one example, and my favorite because it really affects lawyers, they accessed the court filing system operated by the Administrative Office of U.S. Courts. Now, for those who are overseas who don't know, in America, we file most of our court documents electronically now, including confidential documents that are to be sealed, not to be public. But now those documents are available to the hackers who got into our administrative system of courts. And so we are going back right now to filing paper by hand rather than by electronic filing, because we can't be sure that the security of the confidential documents is there. And that means that we are now filing confidential business information, sentencing reports in criminal cases, classified information and classified document cases all have to go back by hand now, which is especially difficult in these times of crisis. So what are we going to do about it? Well, I think the way to sort of begin to think about it is to quote, not me, but one of President Trump's earliest cybersecurity advisors, a guy named Tom Bossert, who left a while, about 2 years ago. And he said that President Trump has left behind a federal government and a large number of major industries that are compromised by the Russian government. And congressional action is going to be essential. We're going to have to fund repairs. We're going to have to mandate repairs, at least in the federal systems. We're going to have to undertake a significant damage assessment of what went wrong. And in the end, we're going to have to figure out what it is as a nation we can do to deter that sort of behavior by other actors in the future. Because without that, we don't know, how to respond future going, and we remain vulnerable to every other actor as we go ahead. So that was my intro. And with that, I'm going to turn it back to Professor Yukins to continue with the other members of the panel.
Thank you very much, Paul. That was excellent. Thank you. Our next speaker is Sandeep Katharia. He's an Assistant General Counsel for Cybersecurity and Security Law for Leidos. Sandeep's worked at a series of companies across the federal marketplace, and he has an undergraduate degree from GW, a law degree from Villanova, and an LLM with us at GW. He's a leader on cybersecurity issues on the bar and a vice chair of the American Bar Association, the Public Contract Law Sections, Cybersecurity, Privacy, and Data Protection Committee. Sandeep and Alex Canizares, whom you're going to hear in a minute, were instrumental in putting together this program. Thank you very much for joining us this morning, Sandeep.
Great, thank you for having me. So that's a perfect segue into my comments about the need for more work to be done by the government. So the Biden administration's had, just a little bit of time now to sort of assess the SolarWinds issue, and of course there's a lot of other major issues going on right now. But as part of the American Rescue Plan, there's a proposal for about $10 billion in funding, and it's designed to address some of these SolarWinds issues. And it remains to be seen whether that'll actually get passed by the Congress. But the vast majority of that funding is for IT shared services within the government. And so that would include sort of standardization of cyber services and across the government to sort of help with security monitoring and threat detection on federal networks, not contractor networks. And in addition to that, there's a proposal for more hiring essentially for the federal CISO, the Chief Information Security Officer, which would facilitate interagency collaboration among the CISOs, as well as sort of additional funding for the U.S. Digital Service, essentially consultants for the government. So I think, a lot of this I would just sort of describe as sort of good governance, good ideas to sort of help the government more effectively address these threats. And I think what we've seen also in some of the testimony of the major nominees is the idea that we need more robust threat intel sharing. And I think that would be certainly within the government as well as with industry. And so I think that's sort of an easy thing. Everybody sort of understands that, but the tougher part, of course, is how to get that done efficiently. And I think, certainly for the folks that are, and I'm a lawyer, so I work with the people that are on the front lines of cyber defense. And I think it's fair to say that those individuals would like to have more actionable information about whether it's malicious code or indications of compromise or attribution information. And they can't always get that from the government. The government's got their own needs for either counterintelligence or law enforcement activities. So there's a balance there that needs to be struck. But certainly that's another a big initiative. I think we'll see more in the idea of threat intel sharing. And you're going to hear more about the NDAA in a minute. But I wanted to highlight one new recommendation coming out of the Cyberspace Solarium Commission just in the last couple of weeks, and it's in the transition book for the Biden administration, and it's for a policy directive that would require threat hunting on defense company networks as a sort of a condition of contracting. And the idea is there's language in the current NDAA about requiring the Secretary of Defense to do an assessment over the next 270 days or so about the feasibility of a threat hunting program. And then there would be a further rulemaking process contemplated by the current NDAA. And what the Solarium Commission has said is that the administration shouldn't wait and essentially should take some executive action. And I think, if you look at the 1739, Section 1739 of the NDAA, the issues are laid out pretty well about what would be in an assessment. And so one of the questions would be certainly is, who's doing this threat hunting on defense company networks? And I should emphasize that we're not just thinking about major defense contractors, but there are hundreds of thousands of companies that do business with the Department of Defense. So companies in Silicon Valley, small businesses, manufacturing companies. And so that's a huge part of the overall industrial base in the United States. And so there's the notion in the statute that there should be some assessment of whether Cyber Command, U.S. Cyber Command, should have a role in that. And of course, that would raise questions from many companies about whether the U.S. government should be monitoring private sector networks. So that's one issue that should be assessed. And then also there's the idea of sort of third-party commercial companies doing monitoring of contractor networks to sort of scan for vulnerabilities. And that idea has some promise, but there's also the potential that if a company is doing scanning from the outside, they may not have the real full visibility or insight into what's actually being protected on the inside. And so there could be the risk of sort of false positives that emerge from that. So I think this is going to be an interesting issue to hear more about in the months to come. And certainly the Solarium Commission has a very important role, but I think the statute, some guardrails, the idea of having a rulemaking and consultation with industry is really important. So thank you.
Thanks very much, Sandeep. That was excellent. I'm going to now turn it over to Moshe Schwartz. He's the president of Etherton and Associates. He previously served as an analyst in defense acquisition policy at the Library of Congress's Congressional Research Service, the job I envy most in the world, Moshe. So, he's executive director of the Section 809 panel as well. He worked with David Rapkin, who co-teaches a procurement reform seminar with me, and he was chair of the Section 809 panel, and he was a senior analyst at the GAO. He has a master's degree from Carnegie Mellon and a law degree from Yeshiva University. Moshe, the floor is yours.
Thank you very much, and thank you, Sandeep. It's always great to actually, I prefer to go before you because after you, I always feel like I'm playing second fiddle. But I do want to talk a little bit about the NDAA, which Sandeep started talking about. But before I do, a little bit about Congress, which I think is important. Two things. The first one is whenever Congress legislates and when there legislative agency action, invariably regulation has to follow. And the regulatory process could easily be a year, as everybody knows. So when we talk about these provisions and when Congress wants agencies to do things, it just doesn't happen right away. And that's something to think about when we're thinking about legislation here. And the other one to set the stage is, Congress and the legislative power, it's a very blunt instrument. It's not very good at being very agile and being very precise to solve problems. It's more of a hammer saying thou shalt do something in this direction, but they don't necessarily even have the expertise to really fundamentally understand some of the nuances. So with that in perspective, in this year's FY21 National Defense Authorization Act, there were 52 provisions that dealt specifically in the industrial base on cybersecurity. Right? That is pretty new. In fact, if you want to give that by comparison, that's almost rivaling the acquisition provisions that Congress passes every year. In fact, in this year's NDAA, there were a comparable number. There were only 63 acquisition provisions. So cybersecurity is now taking up a lot of congressional focus, right? And for this purpose, I think we can bin it into three categories. They added requirements and power. For example, 1716, they gave CISA subpoena authority. They modified some requirements to look at cyber vulnerabilities in major weapon systems. They even extended the CMMC standards saying, okay, DoD, we want you to report back on how well you are measuring up within the services to CMMC standards, particularly level 3, which was interesting to see. But another thing that they did is they set the groundwork for a lot more future action. So for example, they extended the Cybersecurity Solarium Commission's life, which means we're going to get many more recommendations. And it's worth noting that on the Cybersecurity Solarium, there are members from Congress. So that commission gets a lot of attention from Congress. And then there were a number of assessments, like Sandeep was saying, 1736, which is asking for an assessment of a cybersecurity sensor plan, 1737 for threat information sharing, 1739 for threat hunting program. These do not in any way seem to be provisions where Congress is saying just do an assessment and they forget about it and that does not follow on action. The level of this activity seems to imply that they very much are going to be following up with this activity. One question that might be interesting is, does cybersecurity become a perennial focus of Congress, just like acquisition did? So in 1994, Congress passed the Federal Acquisition Streamlining Act. And having spoken to some of the staffers that worked on it at the time, they were of the mind, once that bill passed, is we're done with acquisition reform. We're not going to visit it again for a number of years. well, that actually didn't happen. Now Title 8 is always about acquisitions, and it's always 50, 60, 70, sometimes even more provisions. Will that become what happens to cybersecurity? Is that going to be something that Congress is constantly focused on? So we'll see if that happens, and it is shaping up next year to be something that I think Congress is going to take a lot of action on. And then the third point on the slide is Congress can tell agencies to do things. Congress can ask for assessments. Congress can also take steps to reorganize agencies to make the infrastructure of the agency focus on certain priorities. And that's exactly what they did here. So as we see, they elevated the CISA director from a level 3 to level 2. A level 2 is the equivalent of the Deputy Secretary of Defense. They established the Office of the National Cyber Director and even put into writing that perhaps that person should be on the NSC. They also elevated the position for industrial base within the department. Previously was only a Deputy Assistant Secretary of Defense. Now there is an Assistant Secretary of Defense for industrial base. And since industrial base has a lot to do with supply chain and cybersecurity, that will probably also elevate within the department the focus on cybersecurity. So they're shifting that as well. One other thing that I wanted to mention, and this has been mentioned before, is it's just not cybersecurity, it's the supply chain, right? And those obviously are inextricably linked. There's no question about that. What's being conflated sometimes, and you see this battle playing out, and I think it's going to be playing out in the future, is security, including cybersecurity and where the vulnerabilities are coming from, and domestic sourcing, right? So the traditional domestic sourcing supporters are using the cloak of security to try to promote further domestic sourcing and reshoring. And so the argument that's playing out in that area is it Buy American to protect supply chains and to protect from cybersecurity, or is it a Buy Allies approach? Which approach should one take to try to defend supply chains, including in the area of cybersecurity? So that's one of the areas also I think it's worth watching to see how that emerges. And with that, I will stop and give my time back. Over.
Thanks so much, Moshe. So next will be Sam Singer. He is Senior Counsel for Cyber at Boeing. He's an adjunct professor at Georgetown University Law School. He was previously Senior Counsel for Litigation and Special Matters at the Cybersecurity and Infrastructure Security Agency, which Moshe was just referring to. And after 4 years, we worked there after 4 years as a trial attorney at the Department of Justice. And before that, he was an associate at Sidley and Austin. Sam has a law degree from Emory and a bachelor's degree in political science from the University of Michigan. Sam, I'll hand it over to you.
Thanks, Professor. Appreciate you having me on this program. Thank you to everyone who came before me for the perfect transition. Perfect in a way because after SolarWinds, one of the headlines or the repeated talking points I've seen is that U.S. government was blindsided by supply chain threat. U.S. government ignored supply chain security issues over the last 4 years. But that couldn't be further from the truth, right? In some ways, all we've been talking about is supply chain security. It's just that that conversation and the policies that have arisen from it have focused on untrusted foreign vendors, not trusted domestic vendors, which was the attack method that we saw exploited in SolarWinds, right? And so the two policies I'm discussing today really fall into that former category, and they arise from a very intense bipartisan focus on shielding U.S. technology supply chains from risky foreign products, and in particular Chinese products. As context, it's news to nobody probably on this webinar that the United States does not have a major player in the telecom equipment industry. That's been true for a couple decades, and economists and historians can debate why that has come to be, but it is a reality, and it's a reality whose strategic and security implications took probably 2 decades to fully sink in. As we're moving towards 5G and the next generation of wireless technology, the many security and strategic risks associated with building the next generation of the internet on foreign telecom infrastructure have kind of come into sharper focus. And what we've seen over the last few years is the US government scrambling to impose political and strategic direction over an industry that has historically been private, commercial, and decentralized. We don't have regulatory frameworks in place during peacetime to tell telecom carriers how to design their networks or which equipment they should use. And everything about U.S. government historically has been designed to limit its ability to intervene in those type of private commercial decisions and transactions. We don't have a national champion telecom equipment provider like a Huawei or a Samsung that would allow us to push subsidized equipment on domestic industry. So what you've seen is the U.S. government reaching for whatever authorities it can find to claw back control over this industry and to impose restrictions on the influence of foreign firms in U.S. telecom. Section 889 in many ways characterizes or epitomizes that trend. It is a sweeping restriction on the federal government's procurement of Chinese telecommunication products, in particular Huawei and ZTE, plus certain video surveillance equipment manufacturers. It has 2 prohibitions, a direct procurement ban that bars agencies from procuring equipment or services that use covered telecommunications products, and then a considerably broader indirect ban that prohibits agencies from contracting with companies that use equipment, system, or services which themselves use covered telecom products. And I'll unpack that in a little bit. That second prohibition in Part B took effect this past August. It applies anywhere in a contracting entity's operations. So not just the operations tied to a government contract, but anywhere in that entity's operations, even if unrelated to federal business, and even if the service that is using the covered product is actually a different company altogether. And the characteristic example is an internet service provider using Huawei or ZTE routers to provide network connectivity to an enterprise customer. Those routers are owned, controlled, and operated by that internet service provider. Yet, for purposes of Section 889 Part B, that enterprise customer is using that telecom equipment in a way that is prohibited by the statute, right? So it's not just about doing the due diligence in your own operations to determine whether you have these covered products, but you also are required to look outside to some extent to see what your suppliers and subcontractors are using in providing you services. So for that very reason, in terms of sort of the sheer scope of the prohibition and the scale and complexity of the compliance challenge it presents, Part B of Section 889 really is without, I think, any precedent in federal procurement law. I think we believe it would be one of the most expensive acquisition laws ever enacted. I think the preliminary cost estimates from the FAR Council bear that out. As I mentioned, there's 2 prohibitions. The law itself was enacted in 2018. The first prohibition took effect, the direct procurement ban took effect in August 2019. The indirect use prohibition took effect August 2020. What was interesting is that by July of 2020, so 23 months after the statute was enacted, there was no rulemaking for Part B. We just had the pure text of the statute. For all the reasons I just mentioned, it's quite broad and it leaves itself open to many interpretive questions. I think there's folks on this webinar who could probably testify that at that point, July 2020, the industry sentiment was somewhere between panic and outright disbelief. No one really knew what was going on. Everyone assumed there would be some sort of legislative fix, or the Federal Acquisition Regulation Council would come in with some dramatic clarification that limits the compliance challenge. And when the rule finally did come out, I think the responses were, fairly mixed. In many ways, it did limit the compliance burden. It made clear that this is not a prohibition that prime contractors are required to flow down. So it applies only at the prime level. Subcontractors still have to, ensure that they're not providing covered telecom equipment or services to the government, but they're not bound by that use prohibition. And as for the prime, the FAR Council made clear that the prohibition is subject to a reasonable inquiry standard, which basically it provided assurance that nobody's required to plumb the depths of the supply chain, interrogate every supplier, to determine whether there's a covered component in one of their products. They just have to make a reasonable inquiry, which is really, according to the FAR rule, internally focused on documents and records that the company has about the origins of the equipment. That said, although those clarifications were helpful, and there were others, there's still, I think, a number of remaining open questions and compliance challenges. The rule is still quite broad. The use prohibition that prohibits use of equipment or a service that itself uses, that double use issue, is still intact. And the FAR Council actually, in some ways, has confused matters more, I think, by not recognizing an exception for interconnection agreements or backhaul and roaming services. So it's a complex issue, but to give an example, when you are providing telecom equipment to a company, it's clear that that edge router, the router that connects to the company's network, is going to be covered, but for purposes of the use prohibition. But it's not clear from the face of the statute, and at least until you read this exception, that the internet service provider's backhaul infrastructure, the routers that it uses to pipe data around the world, is whether that is covered. And I think the exception, as at least industry interpreted it, was meant to clarify that it's not, that you don't have to seek an assurance from your provider that every imaginable router or switch used to move their data from one place to another is within the ambit of the prohibition. But the FAR Council actually suggests that it is. And so I think that has created more confusion and has prompted a very forceful and, I think, compelling response from the telecom industry. So that's Section 89. The supply chain executive order of 2019 gave the Commerce Department an interim, a very broad and sweeping authority to block foreign tech transactions that pose a threat to national security. Essentially, it authorizes Commerce to prohibit or unwind any transaction involving ICT, tech or services that are linked to a foreign adversary and that are deemed to pose undue risk to critical infrastructure or national security. It is grounded in emergency economic powers, usually reserved for, quote, unusual or extraordinary threats, the very authority that sort of serves as the framework for most of our sanctions powers. And I think, judging by the industry response to the rule, I think it's fair to say it represents a considerable expansion of the government's control over U.S. technology transactions. The fate of this rule is still unclear in the Biden administration. I think the industry is watching it quite closely to see what the new Commerce Department is going to do with it. But as of now, it is still pending and set to take effect in March. And when it does, I think there will be considerable amounts of previously unregulated technology transactions that will be at least subject to the possibility of regulatory scrutiny or even being unwound, and potentially a licensing regime, not unlike CFIUS or export controls, for companies to mitigate that risk. So really a fundamental shift in the way the government approaches tech transactions. And that's it for me.
Thank you very much, Sam. We are going to next shift to Alex. Sam, it's my eternal regret that you teach at Georgetown and not at GW. So Alex, in contrast, is he's a senior counsel at Perkins Coie. He's also a professorial lecturer. He's an adjunct at GW Law School teaching performance of government contracts. For those of you who don't know, that's really a mainstay course in our program. It's an enormous contribution that Alex makes to our program. We're very, very grateful. He was previously a trial attorney with the Justice Department, where he handled trials, and he handled over a dozen appeals at the Federal Circuit, which is a remarkable record. Before that, he was an associate at Covington and Burling and a law clerk in the Eastern District of Virginia. He received a JD with high honors from GW and a bachelor's degree in political science from the University of Wisconsin-Madison, where he also did studies abroad at the University of Paris 7. Alex, the floor is yours.
Thanks very much, Professor Yukins. So I'm going to turn to CMMC and the DFARS interim rule around cybersecurity. And I think Sam just laid the groundwork very well, because there are a lot of commonalities between the CMMC rule and Section 889. Both are a similar concern, which is supply chain risk, and that has been sort of a theme of the presentation so far, but also the way that the rule has come out. So both Section 889 and CMMC and the DFARS rule were implemented in an interim final rule that effectively became binding on contractors even before it became final. So, and both are on somewhat of a similar track. We expect that the DFARS rule is going to become a final rule sometime this year. But in the meantime, it is being implemented. So what I thought I would do is just spend a few minutes kind of walking through some of the implementation issues that people have raised. When the interim rule came out in September, it went in effect in November of last year. And then people had the opportunity to submit comments, and reviewing those comments, you do get a flavor of the sorts of concerns and interpretive issues similar to Section 889 in that regard. There's a number of terms, there's ambiguities, there's questions that have arisen about how this program is going to be implemented. And there are really two tracks to it. And if you look at the slide, there's sort of two aspects of the rule that you need to kind of separate in your mind. One relates to the assessments that are performed to verify compliance with the NIST 800 SP 171 controls. Contractors that process controlled unclassified information need to comply or cover defense implement these controls. So these assessments are basically meant to verify compliance with those standards. Those controls have been in place for some time under the DFARS 7012 clause for defense contractors. The difference now is that there's teeth behind it. Before, contractors used to be able to essentially self-attest to their compliance. Now there is a mechanism to basically verify that they're complying. There are three aspects of the assessments: basic, medium, and high assessments. The basic assessments are the ones that contractors have to do themselves as a condition of being eligible for award of a contract. Those assessments have raised a number of questions. One, perhaps the most prominent being, what is the impact of that assessment going to be on the source selection process? How are contracting officers going to be using those scores? So when a contractor is self-assessing their compliance with the NIST controls, they submit that information to DoD and they effectively give themselves a score. Now, what is that information going to be used for? Is it going to be somehow used as an evaluation criteria? That's one question that people have raised. Would it be something along the lines of a responsibility issue? Under FAR Part 9, contracting officers need to verify that a contractor is responsible in order to be awarded a government contract. So those kinds of questions are ones that people have raised. Subcontractor assessments is a related question related to these assessments. And I would say also the medium and high assessments, those are performed by the government. And so there's, I think, still some uncertainty about what circumstances are going to be, those kinds of assessments are going to be employed. The definitional aspect of this is also an important thing. So contractors, I think, have raised questions about how do we identify what information needs to be protected? And there are different definitions according to different programs. The DoD assessments are based on the FAR clause, or the DFARS clause, the 7012 clause, which talks about covered defense information. CMMC, which I'll talk about in a moment, talks about controlled unclassified information, CUI. And I think there's still, I think, questions that people have asked about how do we identify this information? How do we know that we have it? How do we know when we receive it? And perhaps most importantly, in our supply chain, for our vendors and our suppliers, how do we know what appropriate level of safeguard needs to be implemented by the subcontractors? Finally, False Claims Act is an issue here for anybody who's making one of these assessments, submitting them to the Department of Defense, having to attest and make a sort of certification that, or a representation of their compliance, raises potential risks if companies are not, deploying the appropriate sort of review of their systems and their system security plan. They could run into trouble. I'll spend a couple minutes on CMMC and just really outline. I think there's a number of issues here related to CMMC that, under the interim rule, will be interesting to watch. I mean, number one is the CMMC program is supposed to be rolled out over a 5-year time period. So unlike the assessments that I just mentioned that are effectively going into effect right away, the CMMC program contemplates a longer phased rollout. And the Undersecretary for Acquisition and Sustainment is going to be playing a critical role in determining which programs are going to be adopting CMMC in contracts going forward. We already have seen word about some of the pilot programs that are going to be potentially seeing CMMC in those contracts in FY21. But I would really, especially under the new administration, look to Acquisition and Sustainment and their new leadership to try to see what is their approach going to be on CMMC and what programs are they going to apply CMMC to. Ultimately, CMMC is a verification system to make sure that a contractor is adequately complying with a new model, which is a maturity model. And there are 5 levels to that model. The purpose of the model is to make sure that, depending on what level of information a contractor has, that it is implementing the appropriate level of controls and also institutionalizing those controls. And that's where this word maturity comes into play. It's not just having a policy, it's actually implementing it and institutionalizing it into your procedures. Ultimately, though, at the end of this program, the idea is to have this be a go, no-go criterion for every contract award, so that every prime contractor that is submitting an award in a contract needs to be certified at the appropriate level for that acquisition, which raises a question. How will the government determine what the appropriate level is or should be for a particular procurement? There are a number of other questions I just briefly raised before we wrap up. One is there's been discussion about civilian agencies adopting the CMMC model for civilian contracts, DHS, GSA. We haven't seen anything sort of formative yet, but I think that's going to be an issue that I would expect to see continued discussion around this year. The CMMC is managed by a third-party accreditation body. This is, they're setting themselves up as a 501c3 nonprofit organization. That raises a number of questions about sort of the role of third parties, essentially carrying out these very consequential assessments and overseeing this assessment regime, outside of the government. I think they're, in the context of dispute resolution, for example, that's a very important issue, given that these third parties are not subject to the kind of judicial review that we're familiar with in government contracts, the Contract Disputes Act, and that sort of thing. Reciprocity issues are also important to keep in mind. I have read reports recently that DoD is in the process of issuing guidance, finalizing guidance that would address the circumstances in which, if a contractor already has been audited under the FedRAMP program, for example, and they've gone through that sort of security assessment related to cloud under FedRAMP, that they can get some sort of reciprocity under CMMC. So I would expect that to be an issue to keep an eye out for. Sam mentioned some of the flow down issues related to Section 889, and it's very interesting to kind of think about the parallels with CMMC. Under CMMC, a contractor under the new rule in the DFARS is required to ensure that their subcontractors have the certification at the quote unquote appropriate level. And people have asked raised the question about what does that mean? And so this really is about protecting the supply chain. And given that CMMC has such a significant impact for small businesses, significant compliance impact for small business, that's really where the rubber meets the road with this program, is how do you get those smaller companies to be implementing these controls, and how does and what sort of responsibility do higher tier subcontractors have to make sure that their lower tiers are complying. So I'll wrap it up right there and turn it back over to Professor Yukins, but thanks very much.
Thank you, Alex. It was a tremendous amount. Thank you for covering all that. We're going to get back to it in the Q&A, and then we'll be talking about it as well in the second hour during the compliance meeting. So I have a bunch of questions, and I'd like to launch them. But if folks from the audience have questions, please feel free to put them into the chat room. I'm going to be monitoring the chat pretty closely. Let me first of all ask if I could put this question to Kate. So Kate, and of course the other panelists as well, how should folks, this is a very complex area. How should folks keep up with cybersecurity developments? It is such a complex area. How do you keep track of how does one keep track of all the various developments in so many different quarters?
It's really hard. As you can see by the content that we've covered today, everything is changing day to day. SolarWinds is an excellent example of that. And the content is actually pretty vast. I mean, cybersecurity as a topic is really deep and pretty broad in and of itself. But when I'm thinking about how to best keep myself up to date or how to keep clients up to date, there's a couple of resources that I would usually turn to, sometimes going to the actual source itself. So for example, in the context of SolarWinds, looking at the notices that are posted by CISA within DHS, keeping your eye on that, so that way you can get the immediate action that you need, especially for relaying information to your forensic teams who are trying to understand what's going on in your network and kind of picking up on the latest IOCs. When you're looking at things like Section 889 or CMMC, I've also found that it's interesting, oftentimes I get more insights from following certain officials within, in particular, DoD on LinkedIn, because they tend to post information there before it gets kind of publicly disseminated and picked up by the press. So that's another kind of unique resource that I would recommend. And then frankly, when it's just hard to distill everything, I'd rely on someone else to do that for you. So folks at Perkins, folks at Crowell, we're always pumping out client alerts whenever we think that something is of particular interest to the defense industrial base. And there are a lot of really great third-party sources like FedScoop, the Washington Post is constantly covering things, the folks at GW are all over it. So there's a lot of different options that you can go through.
Thanks very much, Kate. And one of the nice things about being a moderator is I get to admit when I screwed up. I forgot to do your introduction first, and I'm sorry. So Kate is a partner at Crowell Mooring. She's focusing on cybersecurity. She's a certified information privacy professional through the International Association of Privacy Professionals. She has a JD in national security from the University of Virginia. She studied at the University of Melbourne in Australia. She has a BA from Florida State University, and she did international study in Paris, which seems to be a theme, Kate, among our panelists. In fact, I teach at one of the University of Paris campuses every year, so we all have that in common. So
we're an international crew.
Yeah, and Kate and Sandeep are going to be leading our second hour of the meeting, and we've been putting up into the chat repeatedly how to register for that second hour if anybody's interested in asking questions, having a very informal discussion during the second hour. So for the folks, and we have a question from one of our participants in terms of, this is for all the panelists, in terms of the basic self-assessment, should a defense contractor be concerned if the self-assessment results in a low score? Do we have any indication of what agencies are doing when a contractor's score is low, but proposes a robust get well plan to move towards compliance? What would the response be from the panelists?
I think the most important thing is to make sure it's an accurate submission to the government in this SPURS system. I do think there's been indications that agencies might be using scores as part of responsibility determinations. I'm not sure if that is, official policy. So I do think that the fact that there is a rule now and companies are being measured, required to have these self-assessments should prompt companies to get well fast.
Thanks very much. We got another question. Any thoughts on how the Federal Acquisition Security Council, intersects with these various developments? Any sense of how the Biden administration will further the Federal Acquisition Security Council's work after publication of the IFR, the interim final rule, last September? Any thoughts from the panel?
So that was another interim rule that came out last year from OMB. And I do think that we can expect to see more. I've been trying to look for updates, but I think we could see more in the way of 889 type activity from FASC, and it has sort of interagency experts. But I have not seen anything in the last few months, and they're probably working on major initiatives. But I would expect that to continue to be one of the things. There's going to be a lot of continuity, I think, between administrations in the national security area, and I'd expect this to be one of those areas.
The Federal Acquisition Security Council is worth watching. The Federal Acquisition Security Council essentially had a veto over the commercial platforms contracts that were awarded last June. The Amazon Business, to Overstock.com, to Fisher Scientific. These platforms are opened up to user purchases, but before those platforms were awarded, the Federal Acquisition Security Council had a right under the solicitation to review the proposals and to veto if there were serious cybersecurity issues. So we got a question. What do you think the implications for local and state governments in the procurement of IT products and services are? What do you think the implications for state and local governments are? Do you folks have any views on that? I have some views, but do the panelists have any views on that?
For whatever it's worth, I think that state and local governments are under even greater pressure than either the private sector or the federal government. They are traditionally the least well-funded, most poorly resourced of all the actors in this space. I had, just by way of an example, one private state-based client to whom I made some recommendations for improvement, and the IT people I was working with explained to me that would take 12 cycles of their budget in order to do the capital expense that was necessary to upgrade their systems to implement the changes. And that was before they had to request an increase to cover operations and expenses. So, the whole problem with state and local governments is that they're chronically underfunded. That's not actually a cyber answer so much as it is an answer for almost everything in the state and local space, at least to the extent that I have knowledge of it.
So Moshe had to step away, but I should note that in the NDAA, there was a provision for grants for the manufacturing extension program to extend grants to businesses that are implementing cybersecurity. The state and local governments might benefit from that a great deal. Also, the ABA's model procurement code, which is used by state and local governments across the country, needs to be updated. It hasn't been updated since 2000, and it would be useful to have cybersecurity provisions in there as well. It's kind of an American perspective on law. Most people think of law as a constraint. Americans, in the procurement space especially, use law as a way of transferring lessons learned, best practices rapidly. And if the model procurement code could reflect best practices in cybersecurity, that might help the state and local governments that are relying on it. Paul, we have time for one more question. I think it's an important one. Could you just talk a little bit about, and by the way, the other questions will be carrying over into the second meeting, but Paul, could you discuss just for a minute the Cyberspace Solarium Commission? It really, as Sam suggested and as Sandeep suggested, it has a very important role in this ongoing policy. What is the Cyberspace Solarium Commission, and why is it so important?
Well, the Cyberspace Solarium Commission was a congressionally chartered commission to make proposals for revisions to America's laws and policies relating to cybersecurity. It was quite successful in its initial go round, at least partially in part because its membership included members of Congress. It was led by Representative Mike Gallagher, Senator Angus King, Senator Ben Sass, and I'm forgetting the fourth one, so forgive me, whoever it is. Oh, Jim Langevin. How could I forget him? And so their report last year came with literally 2 to 3 dozen recommendations, ranging from changes at DoD for cyber warfare, warfighting policy, to changes at the Department of Commerce. Approximately a third to a half of those recommendations became part of the NDAA that we were talking about earlier. For example, theirs was the recommendation to create a national cyber directorship at the NSC level. So that commission has been chartered to continue at a lower level of activity for at least the rest of this year, its main goal being to advocate for implementation of those of its recommendations that were not yet included in any legislation or governmental policy. One of the, I think, most salient that we're likely to see in the next year is a debate about whether or not to create a Bureau of Cyber Statistics, which would become a bureau for collecting hard data on cyber security vulnerabilities, breaches, cyberspace hygiene systems. The biggest, I think, legal challenge that's going to come out of that is whether or not that agency has mandatory authority or not to demand data from private sector actors, or whether or not it just will be able to incentivize the provision of that data on a voluntary basis. Which way that comes out will assuredly affect everybody on this call and their companies. There were other recommendations about implementing more risk assessment analyses and things like that that will trail as well. But it should be, it was one of the most successful commissions in recent days. And I think that was precisely because it had congressional buy-in from the get-go.
Thank you very much. Okay. So that's going to wrap up this program. I'm going to turn off the recording and then point folks. I'm going to leave this screen up for a couple minutes and point folks. We're going to take a 5-minute break. So those of us can deal with our dogs and our children on a 5-minute break. And when we come back, we're going to come back in a separate meeting, which you have to register for security reasons. We have a registration requirement. Kate is just posting the registration link there in the chat. If you could just follow that link over, and we're going to then reconvene at about 10:07 over there. So again, thank you very much to the panelists for joining us for a really excellent webinar today. I learned a tremendous amount, and I'm looking forward to our second hour when we discuss some of the compliance issues in more detail. Thanks again, Lisa, for all your help with this. Take care.
Bye, thanks a lot.
Thank you, Paul.